The third important landmark judgment that we would like to discuss, a decision delivered by the Delhi High Court, in particular in the year 2012, and here the very case was relating to F. Hoffmann Ltd vs. Cipla Limited, and it was relating to infringement and violation of patent law. So, in that connection, we would like to that the very case represented a pivotal moment in Indian patent law, particularly in the pharmaceutical sector. This high-profile dispute centered on the alleged infringement of a patent for erlotinib, a groundbreaking cancer treatment drug marketed as Tasiva. The case raised critical questions about patent validity, infringement, and the very scope of protection for polymorphic forms of pharmaceutical compounds. It also highlighted the tension between intellectual property rights and public interest in access to affordable life-saving drugs. And this particular landmark judgment was delivered by the Delhi High Court in 2012, where it profound insights that we found in the very application of the India's Patent Act 1970, in particularly the very provision laid down under Section 3, subsection D, which governs the patentability of new forms of known substances. So, now we would like to discuss the very facts and issues the judgment. So, here, the plaintiff F. Hoffmann, a Swiss pharmaceutical giant known as the Pharmaceutical Links, and a New York based company, were the plaintiff in this case. That is, F. Hoffmann was known for its extensive research in pharmaceuticals and diagnostics, invest heavily in collaborative research, spending approximately 7 billion Swiss francs annually, and with the Pharmaceutical Inc., that is OSI, and along with Future Products Inc., jointly owned a patent for Rultivin, a human developmental growth factor receptor inhibitor used to treat advanced or metastatic non-small cell lung cancer. Rultivin, sold under the trademark Tasiva by the plaintiff, was a tablet formulation approved by the USA Federal Department in 2004 and the European Union in 2005. In India, the plaintiff introduced Tasiva in April 2006, following its registration by the Central Drug Standard Control Organization in the year 2005. So the patent in question was relating to Indian patent number, which was 1096774 or IN 774, was granted in the year 2007, and the very product and the patent given to the product covered both the drug and its manufacturing process. So the plaintiff, under a licensing agreement with OSI dated 2001 was authorized to manufacture, market and enforce intellectual property rights for Tasiva, the anti-cancer drug in India and other countries, whereas the defendant Cipla Limited, a prominent Indian pharmaceutical company, was the defendant. Cipla announced plans to launch a generic version of Rotivin, named as elusive in India for export as reported in the English Daily Mint. In 2008, this prompted the plaintiff to file a suit against Cipla, Cipla 2, alleging infringement of the patent right they got in India as the patent number IN774. So Cipla in turn challenged the validity of the patent and argued that its products elusive was a polymorphic form, that is polymorphy of LOTB hydrochloride, distinct from the patent compound which was a mixture of polymorphs A and B. The dispute was involved in a subsequent US patent, and that USA patent number USA 221, which described polymorphy of L-O-T-win hydrochloride as a more stable form of suitable for tablet formulation. In India, the plaintiff's application for a patent on polymorphy was rejected under Section 3, subsection D of the Patents Act 1970, which required only new forms of known substances to demonstrate enhanced therapeutic efficacy as per the requirement of Section 3, subsection D of the Indian Patent Act 1970. So this rejection became a focal point in the case as Cipla argued that its product, the defendant's arguments, as their products aligned with the unpatented polymorphy, thus not infringing the patent right of the plaintiff, as they got the patent number IN 774 under the Indian Patent Act 1970. So the suit, which was filed in 2008 by the plaintiff in Delhi High Court, seeking a permanent injunction to restrain the defendant Cipla from manufacturing, selling, or marketing elusive, along with claims for damages. So, concurrently, the plaintiff filed another interim injunction application under Adar and Rules of Civil Procedure Code of 2008. So, the court issued a notice on the interim application, and the defendant admitted the marketing of elusive for 3 weeks. The interim application was argued over several hearings, but on 2008 court dismissed the injunction request of the plaintiff, directing the defendant Cipla to maintain accounts and provide an undertaking to pay damages if the suit was declared. So, here the plaintiff F.Hoffmann Ltd. appealed the interim order, but the very division bench dismissed the appeal. In 2009, a subsequent special leave petition was filed before the Supreme Court, which was dismissed on 2009 again, with a direction to expedite the trial without being influenced by the division bench's observation. So, Cipla, the defendant, filed a written statement and a counterclaim on 2008 seeking revocation of the patent number given to the plaintiff, that was IN 774, on grounds including lack of inventive step, obviousness, and non-patentability as provided under Section 3 subsection D of the Indian Patent Act 1970. The plaintiffs filed a reapplication and a written statement to the counterclaim. So, the court framed 5 issues covering infringement, patent validity, to the very effect of that patent given under the United States of America, and that was US 221, and the plaintiff's entitlement to relief, as evidence was recorded by a court-appointed commissioner, with both parties submitting affidavits from witnesses, including experts in pharmaceutical sciences and patent law. The plaintiffs presented affidavits from show after the very cross-examination which occurred in between 2009 and 2010, the final arguments made in the year 2012, and the court here preserved the judgment, but finally it was pronounced in the month of September 2012. Particularly in this landmark judgment, the issues involved, the court framed the following issues, such as whether the manufacturers, marketing and sale of elusive Cipla, the defendant, infringed the plaintiff's Indian patent number 196774, whether Indian patent 196774 is liable to be revoked on the grounds raised in Cipla's or defendant's written statement and counterclaim, whether the plaintiffs are entitled to a permanent injunction as pressed for, whether Cipla proves that the plaintiff's U.S. patent, and that was US 221, indicates that the compound of claim made by the plaintiff regarding IN 774 is a mixture of polymorphs A and B, requiring separation from for acceptable efficacy in its effect on the Indian patent number IN 774. The plaintiff's submission that they argued that the patent of the medicine under IN 774 was a valid patent covering both lutein hydrochloride and K plus elusive, infringed it by replicating the patent compound. They emphasize Trasiva's significance as a life-saving drug developed after substantial research and its global approval. The plaintiff contended that Section 48 of the Indian Patent Act grants exclusive right to prevent unauthorized use and their licensing agreement authorized to them to enforce these rights. On infringement, the plaintiff asserted that elusive content lutein hydrochloride identical to the patent compound and Kipla's marketing violated their rights, the rights of the plaintiff. So they argued that the Indian patent number IN774's claim were not limited to a specific polymorphic form, covering both polymorphs A and B. The plaintiff relied on the technique approach for claim construction, urging, arguing a purposive interpretation to include variants like polymorphy. They cited clinical trial data showing Ilotinib's administration in tablet form predating polymorph's invention to argue that the suit patent encompassed solid forms. And regarding polymorphy, the plaintiffs argued that it was irrelevant to therapeutic efficacy. So, they contend that Section 3, subsection D's explanation, which under Indian Patent Act 1970 consider polymorphs as the same substance unless differing significantly in efficacy, supported their claim that polymorphy fell within the patent of that made by the plaintiff as given by the Indian Patent Act IN 774. The plaintiff also made reference about the controllers order in pre-grant opposition as it was made in the year 2018, which treated polymorphy as the same substance as under the patent number IN774's compounds. So, on patent validity, the plaintiffs argued that Cipla failed to prove obviousness or lack of inventive step. They disputed Cipla's reliance on European patent as prior art, asserting that the European patent structure covered millions of compounds. So, the plaintiff argued that substituting methyl with ethanol required inventive ingenuity, not more mere workshop improvement, and Kepler provided no evidence of motivation to make this substitution. The plaintiff cited cases like Sandbox vs. Matrix Laboratories, and which was decided in the year 2010 to explain its values. So, in response to that, the defendant made the submission that the defendant here, Kiflaw, Limited, challenged the very patent of the plaintiff as under IN 774's validity, seeking revocation under Section 64 of the Indian Patent Act on grounds of obviousness, lack of inventive step, and non-patentability as provided under Section 3, subsection D. Further, they argued that the patent of IN 774 to the plaintiff was a derivative of known quinolin compounds, particularly those disclosed in European Patent 226 filed by the Genica Limited in 1993. So Cipla contended that the very example 50, one of the European patent 226 methyl substitute quinolin was the closest prior at and replacing methyl with ethanol to arrive at rotivin was obvious to a person skilled in the act. So, on the very question here, the defendant Kibla was raised public interest concern, noting that Trasiba cost 4,800 rupees for tablet while Losif was priced at only rupees 1,600, making it more accessible for cancer patients. They argued that granting an injunction would harm public access to affordable drugs, citing the very need to balance patent rights with public welfare. So, in this context, both parties, the plaintiff and the defendant, while making their presentation in the form of arguments on behalf of their claims, in their support, they cited some important landmark judgments such as Dachi Shanku versus Shanico versus Matrix Laboratory, which was decided in 2010. It was cited by the plaintiffs to explain the very values as a measure of drug potency. The case clarified that lower IC50 values indicate higher potency, supporting the plaintiff's argument that European patent 851's compound was the most potent prior act. And another case was referred, that was Gabriel versus British School Corporation, cited by the plaintiff for claim construction principles, emphasizing that courts should interpret patent claims purposefully without relying on external documents like the United States patent of 222 and the Indian patent IN 774 scope. So, as in the case of Galville, the court held that specification should be read in context, which the plaintiffs argued supported a broad interpretation of the Indian patent given as IN 774. So, in this particular landmark judgment, they also led many reference to important cases such as the Webster Inc. versus Ranbaxy, which was decided in the year 2006, then Abbott versus Day, which was decided in the year 2002, then Catnick Components Limited versus Hill and Smith Limited, this was decided in 1982, then also they made reference to Sudir Engineering Company versus Nitco Roadways, which was decided in 1995. So, the very question here was regarding the examination of patent validity. So, the Delhi High Court examined the defendant's Kepler's counterclaim for revocation, which alleged obviousness, lack of inventive step, and non-patentability as provided under Section 3, Subsection D of the Indian Patent Act. Further, the defendant Kepler argued that IN 774 given to the plaintiff was obvious as based on European patent 226, as example 51 supported by testimony and prior at patents demonstrating methyl, ethanol interchangeability. So the court found that here the defendant Cipla failed to discharge its onus to prove obviousness as laid down under Section 3, subsection D of the Patent Act 1970. It noted that the European patent number 226 Marco structure encompasses millions of compounds and selecting example 51 as the starting point was not sufficiently motivated. The court accepted the plaintiff's argument that a skilled person would prioritize the compound and Kepler's evidence did not establish why ethanol substitution was an obvious works of result. The court also rejected the defendant Kepler's bioisosterism argument, finding insufficient evidence of a predictable outcome. Thus, the plaintiff's patent in India as IN 77.4 was upheld as valid. And as regarding infringement, the court's analysis of infringement was central to the judgment. The plaintiffs argued that elusive content allotinib hydrochloride infringing IN 774 the patent received by the plaintiff under the Indian Patent Act 1970 and that polymer V was covered by the patent's claim. Kepler contended that allofic was polymer V distinct from the IN 774, which was mixture of polymorphs A and B, and that the rejection of the IN 507 permitted manufacturers. So, hereby the court emphasized that the plaintiffs were the onus to prove infringement by showing that polymer V was subsumed within IN 774's claims. So, Kepler's evidence, particularly her rejection of the patent of the plaintiff as under Section 3D, was found that polymer V was not patent in India, so the court addressed the plaintiff's fiction argument under Section 3D of the Indian Patent Act, which consider polymers as the same substance unless differing in efficacy. The court held that Section 3, subsection D creates a limited consideration for patentability, not a deeming fiction for infringement purposes. Extending the fiction beyond Section 3, subsection D scope was impermissible, and the plaintiff's failure to prove infringement independently was fatal. So, the very injunction and relief, the judgment relating to injunction and relief given the findings of the non-infringement, the court held that the plaintiff was not entitled to a permission of injunction or damages. The plaintiff's prayer focused on Tarsiva, which was polymorph V, not strictly. Iron 774's compound further weakening their case. And regarding public interest in relation to the very drug, the court briefly addressed public interest, noting Cliff's argument about Eurocliff's affordability as it was costing rupees 1,600, while the plaintiff's Tasiba was costing rupees 4,800. However, since non-infringement was established, public interest did not influence the outcome. So finally, the Delhi High Court dismissed both the suits of 2018 filed by the defendant. The court held that Cipla's lawsuit did not infringe IN 774. So hereby also the court rejected the very suit filed by the plaintiff. And as per the opinion of the court, Cipla's lawsuit did not infringe the patent right, and that was of the plaintiff IN 774, as it was polymorph V not covered by the patent's claim. So the court upheld IN 774's validity given to the plaintiff, finding that Cipla failed to prove obviousness on ground for revocation as made by the defendant in reference to Section 3, Subsection D of the Indian Patent Act 1970. So, no costs were awarded. So, the very loss that was settled in this case was relating to purposive claim construction. The Catnick approach applies to chemical patents, requiring courts to interpret claims to determine the inventor's interest, especially when variants like polymorphs are involved. As per Section 3D, Subsection D of the Indian Patent Act 1970, the explanation of the very provisions consider that polymorphs as the same substance for patentability unless they significantly differ in efficacy. But this does not create a deeming fiction for infringement purposes. So, regarding the very question of burden of proof in infringement, the plaintiff must provide positive evidence to prove that a defendant's product falls within the patent's claim, particularly when variants are involved. Non-disclosure of relevant patents can weaken the plaintiff's case. Polymorphic forms, as explained separate patent application for polymorphic forms, suggest an intent to treat them as distinct inventions impacting infringement analysis. So, here the Delhi High Court made the consideration that public documents like patent specifications, despite procedural objection, as it was laid down in a landmark judgment, and that was relating to Sudhir engineering, and in particularly that important landmark judgment relating to Sudhir engineering, which we would like to make a reference as per decided in the year 1995, and in particularly the very landmark case was known as Sudhir Engineering Company vs. Nitco Roadways Limited, where the Delhi High Court held that public documents could be considered despite procedural objections. So, they are supporting Kipla's reliance on the patent specification and controllers order as provided under the Indian Patent Act 1970. So, here why we complete our lecture on this important landmark judgment relating to F.Hoffmann Law, Roche Limited versus Cipla Limited, and in particularly regarding the very patent tussle and war and infringement of patent as made by the plaintiff, and ultimately both the petitioner, the submissions were rejected, and finally it was decided in the public interest of the very medicine relating to cancer as produced by the Kipla Limited in comparison to the same medicine fighting cancer as it was produced by the plaintiff F. Hoffman on the basis of their price as Kipla's drug relating to that was only rupees 1,600 while the plaintiff's drug was pricing for rupees 4,800. So here why we complete our valuable discussion relating to patent law or in particularly section 3 subsection D of the Indian Patent Act 1970 relating to this landmark judgment. F. Hoffman Law, Roche Limited versus Kipla Limited.